propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.
Well, okay then, I think let's get started. Welcome everyone to our panel, the panel of the Copyright and Personality Rights Committee of the Brazilian Association of Intellectual Property. This is the second day of the second scientific meeting on intellectual property of our association. And we are conducting this panel in English because we have an international guest. So I hope everyone will enjoy it as much as we certainly will. The topic of that we're going to discuss today is the protection of graffiti and street art by copyright law, discussing current and controversial issues. I'll give the floor to Camila and Daniella if they want to say something before we introduce our guest.
Good morning. Good morning, Enrico. It's a pleasure to have you with us. We know that it's a good opportunity to listen your knowledge about the subject.
Yeah, just it. Good morning, everyone. Enrico, thank you again for your time and to share with us all your experience and knowledge. So please just bring us all the ideas that you have.
Great. So Enrico, I'll just read here a brief introduction about you and your career and your background. So Enrico is a reader at City University of London. He teaches, lectures, and advises in IP. His current research agenda focuses on the intersection between IP and technology, as well as copyright protection of non-conventional forms of creativity. Enrico has attracted funds from a variety of institutions, including the European Commission, the UK Economic and Social Research Council, the UK Higher Education and Innovation Funding, so on. Enrico is also a deputy editor-in-chief of the European Journal of Risk Regulation. He has been delivering classes and talks in more than 120 universities and institutions all around the world. I'm not going to list all of them because we wouldn't have time, but he's a visiting professor in the Keio University in Tokyo, in Turkey, New York, Tel Aviv, West Indies, and so on. And Enrico is a real expert in the subject that we will discuss today. I've personally been following his studies and papers on this matter for a few years now, and I think it will be very interesting for all of us. So, Enrico, with no further ado, I'll give you the floor.
Thank you so much. Thank you so much for the introduction. It's a real pleasure to be with you online, and although next time I would like to visit Rio or Sao Paulo, please. let's do it.
Please.
Let's do physically next time. But anyway, I'm gonna now share my screen, and hopefully now you're gonna let's say Zoom. You should be able to see the screen now, I guess, right? Yes, I think so. You see the screen, the slides?
No.
No. Okay, your screen sharing is paused, it says. Very strange. Okay, let's try again. That screen. Okay. Yes, now it should be okay. Okay, so thank you. This is a topic which has kept me busy for a long time, researching. So my research has been both legal analysis of these issues, how copyright and to what extent copyright applies to street art and graffiti, and also ethnographic research, in the sense that I have interviewed many graffiti writers and street artists, asking them what they think about copyright, which kind of protection they would like to have if they want, and so on and so forth. So it's a mix of legal and ethnographic research, which I have been doing. So let's start with, some introductory, words on graffiti. I mean, graffiti is not really a modern stuff. Since ancient times, since Pompeii, wall writings, and we had witnessed human beings painting on walls, drawing on walls. So it's something which has roots in history, I would say, right? Writing on walls. Of course, now I'm gonna focus on modern graffiti. Modern graffiti writing was born in New York, first Philadelphia, then massively developed in New York in the 70s, 80s. Graffiti is about writing names. Graffiti writers, what they do is to write their name in a very stylish, artistic way, sometimes very unreadable to the member of the general public. We need to distinguish graffiti from street art. Street art is a more, let's say, figurative form of art, and there are different techniques such as stencils, and then you have mosaic tiles which are attached to urban surfaces. Wet posters is a form of street art, like stickers as well. Sticker art is very much developed in many cities in the world. It's a kind of street art. Abandoning objects and taking pictures of such abandoned objects is a form of street art. And of course, the kind of research question I've been interested in, the legal issue, is, are these forms of art protected by copyright, and should these forms of art be protected by copyright? These research questions have been encouraged, let's say, have been triggered in my mind by not only living in London, especially in East London, where in the latest 20 years, street art has literally invaded the street, but also from some cases, judicial cases in court, especially in America, where corporations from a different variety of sectors, fashion, food, cars, movies, real estate, publishing, well, they have appropriated basically graffiti for promotional, marketing purposes. Most of all these cases have been then settled out of court without a decision. But I mean, I don't have time to look at and to explain, highlight all these issues, but you can see here the appropriation, the corporate appropriation of these graffiti. There are so many cases here. I have inserted just the ones which have attracted some form of media attention, right? Fashion, and then, this H&M case is very famous. I will be back on this case later on. Again, here, another fashion company, as you can see, another fashion company from Italy. I mean, it's it's what marketing experts of these companies think is that since these artworks are there in the public environment, they can be reproduced. They can be used commercially by anyone. Well, this is not true. I mean, what I'm pushing in my scholarship is that the fact that they are, in the public environment does not deprive these works of copyright protection. Here you have McDonald's, as you can see, appropriating these tags. Again, McDonald's, and then other fashion company, and so on and so forth. So the first issue we need to look at is, originality. One important requirement for copyright protection is originality. No, there is no doubt that most street artworks, the figurative artworks, are original. They're very beautiful works of art. I mean, nobody doubts about the originality. Doubts remain on whether tags are original or not. Tags are the most hated graffiti stuff, hated for the general public. I mean, something similar to tags is in Brazil, the pichação, right? In Sao Paulo, pichação is very much widespread, developed, is a form of calligraphic art, right? I mean, tags in general is calligraphic art, but this is the opinion of an insider, of a person like me who has studied the movement. If we ask our grandmother, she will tell us, but that's visual pollution. That's not art, right? That cannot be original art. What is this? What are you talking about? Well, I understand that, but if we see the same tag on a canvas, we might start thinking, oh, that might be an original art. This is the same work, the same tag, painted by the same writer. The first, it's on a shop shutter in New York. The second is on a canvas, right? But if we believe that the tag on the right, on the canvas, is original piece of art, while the first is not, well, that's not correct, because it's the same work. So my point here is that the surface upon which the work is placed, a shop shutter, a dustbin, should not influence our assessment of originality. It's not in any copyright law. There is no copyright law I have seen so far that says we need to take into account the support upon which the art is placed, the artwork is placed. Tags, in my opinion, can be very artistic even when they are not placed on canvases, right? When they are placed on doors, on dustbin, on walls, on shop shutters, and so on and so forth. They may reach, in my opinion, artistic level. And tags are the first things that writers do. The first things that writers do, right? Writers perfect the tag year after year. So, at least to insiders of this war, tags can be artistic to a certain point, okay? And if we look at this US case, tags, this was a case about a video game producer incorporating into the video game some tags made by a writer. The writer took legal action. The case was not successful for the writer, but obiter, the court, said something on the originality of graffiti writing, of tags, of graffiti writing in general. Look at here. The form of the lettering at issue is arguably central to the artistic expression of particular words. In this unusual context, aspects of the lettering shown in the RIS art, such as the degree of abstraction of the letters, the connectivity of the letters, the relative size of the letters, and the two- and three-dimensional appearance of the letters, may reveal the artist's personal style and strongly influence the total concept and feel of the subject works. Although the works deep and deepens are not themselves subject to copyright protection, the original manner in which Rees expressed these works is protectable in abstract, right? The color combinations and arrangements the Rees art may constitute protectable elements of that artwork. Very clear. Very clear here. The judge thinks that graffiti writing tags can be, in theory, protected by copyright. Okay. What about word messages? Say messages. You know, several street artists, even Banksy. This is John Fechner, a multidisciplinary artist who, in the 70s and the 80s, used to leave these stenciled words in the Bronx, in New York, and advertisement billboards, right? Banksy himself, the most famous street artist in the world. Sorry, the lifestyle you ordered is currently out of stock. I mean, Banksy is very well known for these sarcastic messages. Can these messages be protected by copyright as literary works? Well, the case law, for example, in Europe and the UK on copyrightability of messages, of sentences, is not so straightforward. Well, after a decision of the Court of Justice of the European Union in the case Infopac case, where the Court of Justice said that 11 words in principle may be protectable by copyright as literary works, well, and also in England we had a similar case law. Well, one may say, look, messages could, in theory, be protected by copyright. A single word might be more difficult to protect because it would be de minimis. This is another English street artist. Look, ma'am, I'm painting walls legally now. Who, you know, he likes to leave street messages. These, you may be aware of this French artist who has left mosaic tiles all over the world. He's French, from Paris. There was you can see that his name is Space Invader, because, you know, the kind of subject, the kind of artwork he creates reminds of the Space Invader video game of the 80s, right? There was a case in France where Peugeot, the car maker, appropriated, used one of these mosaic, his advertising message. The artist sued, and the court said something very interesting here, because one of the defense raised by the car maker was, but that's not original, because this artist is basically copying the video game, right? The video game logo, the video game. Well, the court in France disagreed on that, not buy this argument, and say, look, it's an interpretation of the previous video game, no, the Space Invader logo. And also, when it comes to street art, the originality assessment, the assessment of originality should also be based on the location chosen by the artist. Street art is very much often site-specific, right? It does have certain meaning because the artist chose the location in the street where to put the artwork, right? And the judge recognized this site specificity when it comes to assessing the overall originality of the work, okay? That's an important decision. Another requirement for copyright protection in several jurisdictions, not in all, because in America, UK, yes, you have this fixation requirement, but not in continental Europe. I guess also Brazilian copyright law, you don't have a fixation requirement, or it's not very much, you know, demanding as it is in common law jurisdictions. In common law jurisdictions, such as America, you know, the fixation requirement is there. So one may say, look, there are certain graffiti works or street art works which are very ephemeral, right? They last just for a few minutes, an hour, then they are whitewashed. Here I have inserted this image of of Nikita is a Russian artist who does reverse graffiti. It's called reverse graffiti because what he does is to choose a very dusty surface, very dirty and dusty surface, and then come up with these wonderful, artworks. Well, reverse graffiti, which is practiced on dusted surfaces, usually they last very, their duration is very temporary. They might last just for a few minutes, an hour. So one may doubt about the subsistence of fixation requirement, right? Look at the US copyright law. Copyright subsists in work fixed in any tangible medium of expression. One may say, look, but when it comes to ephemeral graffiti, one may say, no, it's not fixed enough. But I think this objection is very weak because the fixation requirement only demands the work to be sufficiently permanent or stable to allow it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. So although ephemeral, its temporary existence is sufficient to meet this requirement, in my opinion. Even a few seconds could be enough to appreciate the artwork. I mean, there are several forms of art, not graffiti, not street art, which are intrinsically ephemeral. Ice sculptures, sand sculptures. These are legitimate forms of art. Nobody doubts about that. So the discussion about the fixation requirement is very debated, but in my opinion, it should not be an obstacle for copyright protection here. And also, a way to freeze fixation is by taking pictures, photographs of the street artwork. In this way, you kind of are able to freeze the fixation requirement. What about infringements of copyright? Here, there was a case in America, this Itoffer Gale versus Home box office case, where the artist, Gale, complained that the defendant, a TV series, a TV channel, had used his mural in a TV series without authorization. So during an episode of the series, a woman walked through the streets of New York and passed just in front of the graffiti-style words, "Art we all." And here the court, however, found no infringement. Why? Because the use of this artwork, it was an artwork on the wall. The two actors were passing in front of just for a few seconds, like 3-4 seconds. The court said that it was de minimis use and therefore not an infringement of copyright. The particular aspect of this decision is that, the director of the movie chose to shoot that scene in front of the mural. So it was a deliberate choice of the director. But even if it was deliberate, the court said that there was no infringement because it was de minimis, right? So it depends on how much you use, right? If, let's imagine there is a music video of a band. Usually music videos are like 3 minutes, right? For a song. If the use of the mural, the band plays in front of a mural for, let's say, 7-8 seconds. Well, 7-8 seconds out of 3 minutes might be a substantial time, and therefore a judge may find that there is an infringement. We need also to talk about the freedom of panorama exception, right? Freedom of panorama exceptions are available in some jurisdictions around the world for artworks which are placed in the public environment. Freedom of panorama. For example, in England, in America, there are some freedom of panorama exceptions for architectural work, sculptures, outside, placed in the public environment. In this case, in the US, Adrian Faulkner, an artist, complained that the car maker General Motors had used its mural in, an Instagram message, promotional message. Here, the car maker tried to defend the case by relying on the freedom of panorama exceptions for architectural works, for buildings. So their interpretation of the provision was, look, you have the mural there, which however has been placed on a building, and therefore it must be considered as incorporated into the building. And therefore I am invoking the freedom of panorama exception for the building. And the design, the painting is incorporated in the building. Well, the judge did not buy this argument and said that there is also no indication that the mural was designed to appear as part of the building or to serve a functional purpose that was related to the building. Instead, there is an undisputed evidence that the artist was afforded complete creative freedom with respect to the mural. The artist was not instructed that the mural should play a functional role with respect to the parking garage, or that the design of the mural should match design elements of the garage. No, the architecture of the parking, said the judge, was already complete before the artist started painting. So the judge here refused to extend the freedom of panorama exception to this scenario, right? In a similar case, Mercedes-Benz was accused of using three murals. Here you have the image of just one of them. Again, in an Instagram message, promotional Instagram message. The artists complained. Mercedes started a legal action in America asking the judge to declare that this was a freedom of panorama scenario, because again, the painting had been incorporated into the architectural work in the building, and therefore there was freedom to appropriate them. Well, the case was settled out of court. But I mean, you can understand that this is a very sensitive issue, right? A very sensitive issue. Because if a judge finds otherwise, if a judge finds that these attempts to incorporate and to appropriate the mural by relying on the freedom of panorama exception, well, that would be a free pass, a green light for corporate appropriations of many murals around our cities, especially in America. So it's a very sensitive issue, right? So far, we had just the previous decision, right, here in Faulkner versus General Motors in USA, where the court said, no, it is not a case of freedom of panorama, but it was a lower case, a lower court decision from a lower court. We don't know if a court of appeal or in the US Supreme Court might find otherwise, and that would be very dangerous for the artist, right? Another important issue is the issue of illegality. Many street artworks are still produced illegally, both graffiti and street art, right? So that means without authorization of the owner of the wall, right? So the question is, should we give copyright protection to illegally produced street art and graffiti? Is it a paradox to give protection to these works? It would be, someone has said in the past that granting copyright protection for illegally produced works would create a paradox, would basically incentivize illegal activities, right? Many commentators have proposed to exclude copyright protection. Well, and the illegality of the street art has been used by several defendants, or anyway companies accused of appropriating graffiti exactly to defend their case. For example, H&M in this litigation said, look, the artwork in question, which has been used as promotional backdrop for a campaign by H&M, this artwork has been created illegally in Brooklyn, and therefore I can do whatever I want. I can appropriate it commercially because there is no legal copyright protection. The same for Italian fashion company Moschino's, defending the case in America and saying, look, I'm not a copyright infringer here because this artwork has been made illegally and therefore there is no copyright protection. But is this really a suitable doctrine? Because what these corporations have used as a defense is the so-called unclean hands doctrine in America, which is an equitable doctrine. In general, used by courts when plaintiffs, claimants have committed a crime and they try to monetize out of their crime, right? So, for example, some serial killers in the US have tried to write books about their killings. State court, relying on state laws in America, have denied the enforceability of any copyright in these books by relying on the unclean hands doctrine. Your hands are dirty, you have committed a crime, you cannot claim, you cannot enforce copyright before courts or any right. But, and it seems that in this case, Villa versus Personal Education, it was a case where a publisher of a photographic book of graffiti used a mural by Villa, this artist. Well, Obiter, the US court here, said that whether the defendant, the publisher, would be liable for copyright infringement would depend on the factual questions of illegality, suggesting the application of the unclean hand doctrine to this scenario of illegal graffiti. But it was an obiter, it was a lower court decision, so still is not really certain, right? Whether illegal graffiti is protectable by copyright in America. Many commentators believe so. Many scholars believe so. I do believe that the application of the unclean hands doctrine to the graffiti scenario is not appropriate, because who misuses the art here and invokes this doctrine is not the victim of the vandalism, is not the property owner. If there is a victim, sorry, is not the victim of the vandalism. The corporation which raises this defense, the corporation which appropriates the mural, the illegal mural, is not the victim of the vandalism. If there is a victim of the vandalism, it's the property owner, not the owner of the wall upon which the artwork is placed. Whoever is not involved in these disputes, right? So, in my opinion, accepting the unclean hands doctrine would lead to an absurd result, because it would end up rewarding people and companies that are not victims of the alleged vandalism. In other words, applying the unclean hands doctrine to the scenario of illegal graffiti would legitimize the co-option, the misappropriation of street art, but not its very creation, which would be absurd, in my opinion, right? So I do believe that the process of creating an artwork is irrelevant under copyright law. If I steal from my friend a pencil and then I start, drawing a wonderful piece of art, why should I be denied the copyright of that? No, I might, of course, I will pay the consequence for such an illegal act, but I should be able to, rely on my copyright, enforce it if this is necessary. So in my opinion, copyright is neutral, copyright is blind towards the illegal or legal, process of creation. There is no paradox, in my opinion. Criminal and copyright law would go in parallel here. So you could be condemned criminally under criminal law, but you should be rewarded under copyright law. I don't see any paradox. However, one may say, but it is really convenient for writers or street artists who have committed a crime to, come out and start a legal action. They would probably need to reveal their identity in the complaint. It would be like, a confession on papers about about committing a crime. So also in my interviews, many of the writers say, no, I don't want to come out. I don't want to risk prosecution. That's quite understandable. But however, in many countries, there is a statute of limitation. 5, 6, 7 years, you are not punishable anymore. And therefore, the interest in starting a legal action might be there after the statute of limitation expires. And indeed, in this case, we have seen before, who brought the action was the fiancé of the artist, because the artist died in the meantime. There was no risk, because it was another legal person, natural person bringing the action. Now, let's move at the moral rights, especially the moral right of integrity. Are street artists and graffiti writers able to enforce the moral right of integrity? For example, to prevent the destruction of their works, the whitewashing of their works? As you all know, the moral right of integrity under Article 6 bis of the Berne Convention gives artists the right to oppose treatment of their works which are prejudicial to their honor or reputation. So what about whitewashing? If they are interested, because many artists, many street artists, might not be interested. This has been confirmed to me in many interviews I had. They are quite happy with a digital photograph, right? That they disseminate in the internet, Facebook, Instagram, whatever. But some of them might be interested in enforcing it. Well, we had a case in New York a few years ago, right? 2018, there was a decision by the New York judge, Mr. Block, finding in favor of 21 artists who had painted at the famous 5 Points mural point in Queens in New York. It was legal graffiti, it was not illegal, so they were authorized by the property owner for many years. But in November 2013, the property owner decided to whitewash at night without notice all the artworks. Yes, because he wanted to destroy the site and build up luxury condos, right? However, the property owner did not comply with the requirements under the Visual Artists' Rights Act in America, which is the piece of legislation which protects the moral rights of the visual artists. And there is a provision in the Visual Artists' Rights Act which says that visual artists have the right to prevent destruction of their works if their works are of recognized nature. And the judge in this case accepted that graffiti artworks and street artworks can reach that level of artistic merit, recognized stature. It has been the first time graffiti and street artworks have been protected under this piece of legislation. The first time that these are kind of forms of art have been recognized as having recognized stature. So a very revolutionary decision by the judge, which may also change the perception of these forms of art amongst the general public, right? Another reason why the judge found in favor of the artist is that it's procedural, because the property owner did not give the 90 days notice. If the property owner gives the artist a 90 days notice, allowing them to try to save those artworks, at least those artworks which can be saved without, having an impact on the building. And some of these artworks could have been saved because they had been placed and painted on removable panels, so they could have been saved. But the property owner did not serve such notice, and therefore, also from a procedural perspective, it was not complying with the law right? So a very important decision, a 5 points decision, which is a landmark ruling. There have been then previous, before the 5 points, other cases of muralists trying to enforce their moral right of integrity. Now we don't have time to go through all these interesting cases, but I will send Pedro the slide, so you have here the references. So if you want, you can get more information. Also in my papers, there are some summaries of these cases. So what can we say here? That there is, there is clearly a tension between the rights of visual artists, the right of integrity, and the right of property owners, right? There is a clear clash here. And of course, judges, if there are disputes, they need to find a balance on a case-by-case basis, right? They need to reach a decision by taking into account several factors. The existence of any agreement between, previous agreement between the artist and the property owner, if there is an agreement. The length of time the artwork has been allowed to stay by the property owner, the advantages obtained by the property owner from the piece. And in the case of 5 points, the property owner got some advantages. I mean, because these artists revamped the area in the 15 years they were allowed to paint there. It was a crime-ridden area in the Queens in New York. After, these artists revolutionized the area, it had become a quite, cool environment, cool area. The public interest served by the proposed new use of the property once the street artwork is removed, the change of destination of the building, the necessary adaptation to modern functional requirements, the cost of maintenance and restoration of the mural by the property owner. Think of Banksy. Many people believe, okay, if one day in the morning I wake up and I see a mural by Banksy on my wall, I start jumping of joy, right? Because my house now is valuable 1 million, 2 million, dollars.
You'd be super rich, Enrico.
Yes, that's true. That's the first feeling, Pedro. But there have been cases where property owners have become really annoyed by the fact of having a Banksy on there. Why? Because the cost of maintenance had skyrocketed. You need to hire 24 hours a day, 7 days a week security to, to save the artwork, because then, you have vandals, you have taggers, you have people who try to steal, you need to place glasses. I mean, the maintenance is going to be very expensive, right?
A bunch of people taking pictures in front of your house.
Yeah, I mean, so it's a factor which needs to be taken into account. Then, whether the owner commissioned the work or not, this is another factor which judges should take into account. Whether the owner is an organization upon which the moral duty lies to take good care of cultural heritage, and so on and so forth. There are several factors that need to be. Then let's look at 2 cases important. The protection. I mean, can property owners destroy, whitewash murals that have been placed illegally? When one may say, yes, of course they can. It's reasonable. They didn't ask for it, right? It's illegal. And in this case, the US court said, of course they can, because otherwise artists could effectively freeze redevelopments of vacant lots by placing artwork there without permission. And such a construction of the statue would be constitutionally troubling, would defy rationality, and cannot be what Congress intended in passing VARA. But in a subsequent case, another US court said that the finding in the previous case, in the English case, so the inapplicability of VARA to illegally created works, only applies to illegal works that cannot be removed without destroying them, impliedly suggesting that in case of illegal removable works, removable panel, destruction may be prevented by artists enforcing the moral right of integrity. So it's still an area which is not so, an area of law which is not so straightforward. No, the court said in this case there is no basis in VARA to find a general right to destroy works of art that are on property without the permission by the owner. Okay. Let me now talk about finish this talk about another treatment of the artwork, not destruction, but what I call decontextualization. What does that mean? There have been cases, Banksy murals and other famous murals by famous artists, where people, organizations have cut the mural from its original place, a wall, and relocated such mural into an indoor space, museum, galleries, often for the purposes of being resold, offered for sale. Well, there is no case law on that, but I am pushing the argument in my scholarship that this decontextualization should be considered in some cases as prejudicial to the honor and reputation of the artist, and therefore a violation of the moral right of integrity. It has happened with Banksy, as you can see here, with Stick, another London artist. Here he painted this community mural in Poland. After, in 2011, in 2015, chopped pieces of the mural reappeared, resurfaced in a London gallery, and they were offered for sale for 13,000 pounds each. This is not even just decontextualization, this is also mutilation of the artwork because they've been chopped, but also the previous Banksy has been chopped. But even where the decontextualization is executed perfectly, let's say, right, with no mutilation, I would like to push the argument that this is still a treatment of the work which is prejudicial to the honor and reputation of the artwork, because it's a kind of mutilation, because it's, you know, most street artwork, especially Banksy's ones, are site-specific. They have a meaning because they have been placed in that particular street, close to that particular supermarket. You remember the French artist case, the Space Invader decision. The choice of the location is part of the artistic concept, right? If you change the location, you change the artwork, basically. So there is no case law, but in my research, I've been pushing, I've been advocating for this. I hope that sooner or later, when this happens, the artist takes action for a violation of the integrity right, and the judge can recognize, you know, this violation, let's say. Let me finish this by saying that in the US, however, the decontextualization is not relevant under VARA because in a couple of cases, one of these is Kelly versus Chicago Park, the courts said that the Visual Artists' Rights Act, the right of integrity under this piece of legislation cannot be invoked for site-specific works. So site-specific works, I mean, they can be relocated without violating, basically, the moral right of integrity. This is at the moment the case law in America. Let me conclude with, I mean, there is not just the moral right of integrity that could be enforced by muralists to protect their artwork. There might be a move by the state, but this is not anymore the province of copyright law. We are here in the area of heritage law, right? There are, at state level, at the national jurisdiction level, laws which protect artworks that have a strong cultural significance, right? And they must be protected. So here the push to protect the artworks, you know, the murals, comes from a public interest element, let's say, and which is embodied in these national heritage laws. For example, this mural by Keith Haring in my hometown, Pisa, in Italy, is protected under heritage law. So it must be safeguarded, must be maintained, restored, and so on and so forth. So this was, you know, my presentation, and then I very much welcome comments from the ground, from the audience. Also because in Brazil, you have wonderful pieces of street art, Os Gemeos and Ina Pandolfo. And also, I personally love Pichação as a form of art. Probably there are many people in Brazil that don't like Pichação, but is a form of art which, in my opinion, would deserve copyright protection. So I would like to know your opinion on that. I mean, and also hear some comments.
Great. Thanks, Enrico. Thank you very much for the presentation. Angelica, can we open to the audience for questions?
Oi, doutor Pedro.
Oi, Angélica. A gente pode abrir para perguntas?
Pode sim.
Tá bom. Well, Enrico, while we invite people to ask questions, I just wanted to say that it was amazing as usual. I mean, there were so many interesting subjects. I mean, when you brought about the originality also based on location, like the overall originality issue, that's quite interesting. Freedom of panorama, as we've discussed it before, we do have in our case law some decisions that took into consideration freedom of panorama, not exactly using this term. We usually refer to as the surrounding context where the work of art is situated, but it's basically the same concept. And just one comment that I would like to make, and that's quite interesting. It's since you've mentioned our pichação a lot, is that graffiti was actually a crime here, not just pichação, but also graffiti was a crime until 2011. And in 2011, our law changed, and then only pichação remained in the law. It's a law about environmental crimes, federal law on environmental crimes. It still says to this day that pichação is a crime, but with a really the penalties is quite low.
I guess the general public in Brazil, in Sao Paulo, are against pichação, or there is some understanding of the artistic level of pichação?
That's a tough one. That's a tough one, Enrico. I would say it should be divided. You're on mute, Camila. Sorry.
I said it was sort of controversial, in my opinion. So we have people.
Yeah.
No, I mean, like tax, as I said, 90%, 99% of the people in the school, they believe that it's just, what is this? But
it's still in our law. It's still there. That pichação, it's a crime, and graffiti was there until 2011, so super recent.
Pedro, just a comment. It's not an environment crime if you have the owner authorization to do it.
Yeah, sure.
Yes, of course. Yeah, sure.
That's
sure.
Sure.
Yeah. And this change in the law, it was also interesting because it removed graffiti from the prohibition, but it also added a paragraph expressly authorizing graffiti. So it was like a really 180 change. But let's hear from the audience. I don't know if anyone wants to ask questions to Enrico.
I guess people were just like trying to simulate all the information and all the knowledge that he could just bring us, and it was super nice.
Valdir
Valdir
says, one of the hottest issues here in Brazil is the use of street art as background for commercials. How do Italian and perhaps European laws address fair use in advertising when the work of art is in public places? Well, it's difficult to use fair use for overtly commercial uses of street art. I mean, fair use might be invoked when there is a use of street art which is cultural use, research use, or use for the purpose of commentary, a website which wants to comment on the street art. But, when it comes to commercials, and, the examples we have seen, this is a very clear commercial exploitation. So I would say it's very difficult to claim fair use in the US or fair dealing in UK, or, when it comes to so straightforward commercial uses, I would say, by corporations. I don't see much space for a fair use, defense there. And indeed, in the US cases, what they try to do is to use the freedom of panorama, which is not strictly fair use, is another kind of defense, right? Different, as I said, would be the use in a website which criticizes street art, which, but, when you use it as a backdrop for a commercial advertisement, it's very difficult. Yeah. Although there are cases in the US where fair use has been used also for commercial activities. Parody, the Pretty Woman song parody was considered fair use, and it was a commercial product. But in case of street art and graffiti, I mean, I would think it's more difficult.
Great. Thanks, Valdir, for your question. Anyone else? Yeah, I kind of agree with Camila and Enrico. I think everyone's still absorbing.
Yeah.
I mean, too much information.
Yeah, and I'm worried about your next meeting or class that you have, like in 3 minutes, actually.
And you have to run in the halls of the university.
Yes, I'm sorry to be so
No.
But I hope that it has been interesting. I mean, if you want to go in depth, I have written many papers. Also, a book has come out just last month. So many cases that I have just mentioned here are there more analyzed. I can send you as I said, I can send you the slides there.
That would be great, and I can share with the audience.
Yes, with also some links to papers that I have written. So there you can find even more information.
Okay.
Yeah,
Okay.
Oh, perfect. Enrico, well, thank you very much.
Obrigado. Obrigado. Bom dia.
Grazie
I hope
mille.
to, I hope to visit you in person someday.
Please come. It was great.
Okay.
And it would be great to hear you here in Rio or São Paulo.
Yeah. Absolutely.
Thank you very much, Enrico. Grazie mille.
Bye.
For your
Ciao.
valuable
Ciao.
contribution to our
Thank you,
panel.
Daniella. Ciao. Bye-bye.
Thank
Bye-bye.
you.
Bye.
Bye-bye.
A propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.